Hello, everyone, and welcome to this new episode of the Privacy Rules Meet the Member podcast. My name is Alessandro Via. I'm Executive and Legal Assistant at Privacy Rules. And today I'm joined by our colleague Ruth Ng, that comes from Taylor Vinters Via, that is our law firm in Singapore. Hello, Ruth.
Hi.
How are you?
Good. How are you?
Very well. Thank you. Ruth is an intellectual property law and technology law practitioner, and she is currently senior associate at Taylor Vinters Via. Her practice involves international transactions and mostly clients from the international sector, dealing with medical technology industry, blockchain, and software companies. She also deals with businesses that rely on big data analysis, right?
Yes.
Yeah. And what about your firm? What about Taylor Vinters Via?
So Taylor Vinters Via is, we do specialize mainly in tech and intellectual property law. So as you said, a lot of our clients come from the international backgrounds and networks, but we also have quite a lot of clients who are locally based startups. So we also help them with the corporate side of things, fundraising, or just setting up of their corporate structures. And we also do things like IP portfolio, assisting clients with IP portfolios, registering patents, trademarks, and so on and so forth.
Yes, the Taylor Vinters is a very well-recognized firm in the media and technology sectors, also by important directors.
Yeah.
Ruth, the time is pretty short during the podcast, so I would like to immediately start discussing about our main point, that is, of course, data protection. I would like to know and have a little overview on how it works, the data protection framework in Singapore, and which are the main characteristics of it.
Okay, so Singapore has a pretty straightforward data protection laws. In about 2012, that was when we first enacted the Personal Data Protection Act, which is the main act in Singapore that governs personal data. It's quite similar to what you'll find in most other countries because it's based on the OECD privacy recommendations, and consent-based. Talking about how do they define personal data. So a lot of times we refer back to the Personal Data Protection Act, which short form PDPA. There are other acts also, but that's probably the main one. Yeah.
Okay, I discussed with you a bit of the data protection framework in Singapore. I'm curious because you defined it business-friendly data protection. Yes. Why you say that, and is that a specific characteristic of your law?
There are quite a few differences between how privacy is treated in Singapore and in foreign jurisdictions. And you'll find that a lot of the times, like in discussions, government release papers, when we choose to move apart from certain other practices in the world, we always go back to the root as to why do we have privacy laws in Singapore. And, it's not because I think perhaps it's also because of an Asian background, we don't really see privacy we don't see privacy the same way as Western countries, as a human right. Okay. But more, in our parliamentary debates, when we were going to enact the PDPA itself, we would actually talk about being more aligned with business practices, commercial practices, and installing consumer confidence. That was more the driving force. And I think you can see that a lot as well when we talk about what the laws are and how do they work in Singapore compared to other jurisdictions. Okay. So, which is why you'll find that our privacy laws here in Singapore are not as, they were designed not to be as difficult to comply with for businesses, not to increase costs for businesses. Those are, things that they will actually talk about during our parliamentary debates. How do we not overburden our local businesses?
Okay. And do you have kind of example that can clarify how your law tries?
So I think one of the more obvious examples is, we have a consent-based regime, but there are a lot of exceptions to it. And one of the exceptions would be you don't need consent if you are collecting employee candidates data. So the reasoning is that, the logic behind it was, if you are interviewing someone, you don't want to have to ask them for, can I have the right to do background checks on you? Because, the idea is you don't want to tip off the person to go and hide data. The law kind of recognizes that as an employer, you should have a right to ensure that, this person checks out what he says is true. So that kind of differs quite differently from other countries where they're like, no, a person should have a right to how much data is exposed about him before he's hired. And some countries are like, I don't need to, I should have a right to know to whether or not my employer can check my credit rating. Whereas in Singapore, it's kind of the other way around.
Yes, and that's a very good example, since with the GDPR, many human resources team are facing problems exactly with of situations when you speak about new employees, you are searching for new employees, and how to manage that kind of data if you can transfer it to other branches you have of your firm in
organization.
Yes, and under this point of view, how it works for the transfers of data in Singapore, for example, if I want to transfer
out
to an information from Singapore to another country, do you have to certain rules to respect, or?
So I mean, for us, the rules are quite similar to what the OECD recommendations are, which is that if you're going to transfer data out, you have to ensure that the data is going to be afforded the same level of better protection as it would in Singapore. So in that sense, we're quite close to the international standard. But I think, with the GDPR coming in, and they're a lot more strict now about how do you transfer data out. You need certain permissions, you need to have certain things in your contract. So, I guess now also we're also thinking about, the country's also thinking about how do we improve our standards, yet also not be overburdensome on our businesses.
Okay. So there are new changes that are moving in Singapore, and there are new proposals, new ideas you think are particularly interesting in the data protection sector to be mentioned?
Yes. So you find that in the last 2 years, there have been a lot of discussions in Singapore, a lot of back and forth, a lot of consultations being released by our Personal Data Protection Commission, which is the main authority for the PDPA in Singapore, where they talk about changes, pending changes to the PDPA, things like introducing mandatory data breach notifications, things like changing our consent regime, introducing data portability, which are, I think a lot of countries have been doing that, and which is why Singapore's looking at it now. A lot of these changes are due to the bill itself is due to be released early next year in 2020, and then probably the changes will come to force end of the year or maybe latest 2021.
Okay, and you already have an overview on what these under?
We do. We have. I mean, even for some of the consultation rounds, we've written into the PDPC as well with our views. Taking into account how our clients' practices are usually like and their concerns. We do weigh in. As I said, some of the changes would include changes to the consent region. And actually, if you read the consultation papers released by the PDPC, you find that a lot of it is driven by a desire to make lives easier for data-driven businesses and technology and innovation. For example, just the last, I think February or March, there was a paper released where they were talking about this idea of a innovation exception to consent. So if I want to use data for innovation purposes, there is an exception underneath the consent regime, which is quite interesting. I don't think I've seen equivalents elsewhere at this point in time.
No, for sure. That's really interesting indeed. And so yes, consent regime is always one of the main topic of data protection and privacy protection. And it's interesting to see that Singapore immediately started to work on that point, even if it already has a regulation that was also complying with consent. It's not the first time that you deal with consent. You're just modifying the rules.
Yeah.
And this is going to make it more business friendly, as you say, or you think it's okay?
I think that the goal is to attract more tech companies and more innovation-based businesses to Singapore. We have things like a data sandbox where businesses that deal with big data can actually come to Singapore and get exceptions from some of the laws and regulations even, and function within that sandbox to work together with regulatory authorities to kind of push the boundaries of innovation without being suffocated by data regimes, which is quite interesting. I think that they are trying to play a very trying to strike the balance though, because if you're too liberal with your privacy regulations, you also run the risk of not being able to inspire consumer confidence. You also run the risk of not being aligned with international practices. So it becomes very difficult then for local tech companies to then expand overseas because they're too liberal. So it's quite interesting to see the changes and the balances come out.
And speaking about businesses and the fact that you want to attract new business in Singapore with free and regulation, do you have also data breach notification system, or there is something?
For now, So for now we don't, but it is due to come into play sometime next year, or together with the PDPA bill. We do have a cybersecurity breach notification system, but that's only for critical information infrastructure. But I think the PDPC recognizes the importance of having a mandatory data breach system in place.
So under this point of view, maybe your regulation is going to be more similar to the GDPR, asking for a mandatory notification regime.
Yeah. Yes. I think even, when we talk about the GDPR, you already have like the PDPC thinking about how do we make it more streamlined for businesses so that, let's say if they have to report to the EU authorities, can the report be similar? The report be something that the local authorities can accept to reduce the inconvenience for the business.
And I see you mentioned also, when you're thinking about the new regime that is coming, changes under the data portability.
We're actually going to introduce data portability.
Okay.
So
because you don't have it.
Yeah, we don't have it now.
Okay.
It's interesting because even within our firm, we were thinking about how will the future of the data industry go when it comes to data portability? Is it just simply transferring things via a hard drive, or will the blockchain actually come in and make this a whole new ballgame? Where as the data subject, I have control over who I give access to my data on the blockchain.
And perfect. And so, do you think which are in your mind? We always compare regulations with the GDPR because actually is the most followed regulation around the world. So we always like to trying to make comparison on which are the main differences or main similarities between the two regulations. Do you have your personal idea on which points are more common and which are more different?
I think the most similar points would be consent being the basis, obviously, and another one that is quite interesting is the DPO requirement.
Mm-hmm.
So I think under the GDPR, data protection officers are required for certain situations, and in Singapore we also do require data protection officers. There are some slight differences between the frameworks. For example, under the GDPR, not all organizations, from what I understand, need to appoint a DPO. Whereas in Singapore, we do have to appoint DPOs for
in
all
any case.
organizations.
Okay, that's really. And which are the requirements for a DPO? Because like in under GDPR, they needs to be recognized somehow. There is not a specific request of certification, but normally if you have, depending on how big is your company and the kind of data that you're handling, you need to have more expert DPO and someone that has more knowledge in that sector. It works in the same way in Singapore?
Not quite, I feel. We do, I mean, the PDPC will say that, you know, you should be familiar enough with the rules, with how data works and whatnot, but we don't have specific requirements like saying they must be certified or must have certain expertise. I think the other similarity also is that the DPO is not personally liable under both the GDPR and
so it's quite well protected at this point of view.
in that sense, you know, it's quite daunting as a DPO sometimes, especially in this whole new area of practice and, you know, being concerned about data protection, which is it's a fairly new concern, I feel, still.
Yes, definitely. That's definitely true. And then, and in Singapore, you have your authority that control that everything is in compliance with your regulation.
Yeah. So that would be the Data Protection, Personal Data Protection Commission.
Okay, and that the Personal Data Protection Commission can make fines for not compliance with the regulation.
Yes.
That's the strongest power they have in case of breach of the regulation, let's say, violations.
Theoretically, technically, you can actually be imprisoned for offenses, but that's never happened so far in the last 7-8 years.
Okay.
Fine-wise, the maximum fine that can be given out is 1 million Singapore dollars, but I don't think they've given out such huge fines yet of that amount.
So Singapore's companies are normally pretty compliant, because I see that there are not many fines.
Maybe they're not published. That's the thing.
Okay.
But I think the PDPC does a pretty good job in
yes, I mean it's
a lot of guidance to businesses in Singapore.
I see that is one of the authorities that is more active also to providing materials in order to respect the regulation. That's probably the best first step in order to avoid violations of the regulation. So surely they are doing a good job under this point of view, because also from Europe we know about PDPC and what they do, and when they provide new materials, it's always interesting to have a look on what is there. Okay, which are I would like to move now to the last part of our discussion, also because we don't have much more time, and that is the practical one. Considering all the things we have discussed about today, which are the main practical issues that you face every day in your activities with data protection?
I think day-to-day wise, the thing also is for personal data, a lot of the businesses that get tied up in personal data are more likely to have a very international element in their business, or at least when I deal with them. So let's say tech companies, right? You know, you can't just comply with one country, you can't just comply with Singapore's laws. You would have to consider EU, you have to consider, you know, China even sometimes, or just all the jurisdictions. Like if you're running a online travel platform, you can't just care about one country's laws, because you're going to be collecting data from so many countries and dealing with properties in so many different countries. So, you know, the challenge is much more than just caring about your local laws. It's also trying to figure out a way to ensure compliance with as many jurisdictions as possible. So in that sense, I think that's the challenge of today. I think that the way to deal with that is to have a very good network of privacy practitioners, as you know, PrivacyRules aims to be.
Yeah, that's what is that's a good reason to be part of an alliance as PrivacyRules, where you can find colleagues or other experts in the same sector to contact just in case you need help for your clients. And that's basically one of the main ideas, to be sure that you have another firm that has the same level of expertise in that sector that you can contact if you need. And that's something that happened also in Europe, even if GDPR looks one unique regulation. It's not like that. Every country can modify and apply GDPR under a certain point of view in a different way. So it's always good to have a network and to discuss together with colleagues. And that's, I think, something that works globally in the data protection sector, because data flows everywhere and there are many different regulations to be respected. So I think that's a very good point. And is there anything else you think it may be of interest in this discussion on Singapore, for Singapore companies or companies that would like to move their business to Singapore?
I feel that if you're a data company, it's good to have a research center in Singapore, because the laws are very supportive and make the research and the testing a lot easier. And it's a pretty nice place to do business, even if you're not in the tech sector or data sector. It's very easy to start up a business here and to run it.
Yeah, because you have a business-friendly regulation. So
yeah, and we're pretty smacked in the center of Asia and the ASEAN region and English-speaking countries, so it makes things a lot easier.
Yeah. Yes, for sure. Yes, for sure. I understand. Well, Ruth, I think we ran out with our time, so I really want to thank you for staying with us today. It's been really interesting to speak with you and know a bit more on how it works in Singapore. We invite our members to find you and your colleagues in our website, where they can find your contact informations and contact you if they need for some advice in Singapore in particular. So thank you very much, and I hope to see you very soon.
Thank you. It was nice speaking to you. Bye.
Very nice.